Hello everyone, welcome to today's special webinar event. I'm Terry Ryder, founder of hotspotting.com.au, and today I'm speaking with Tom Wood of FC Lawyers on the important topic of how timely advice can save you a small fortune. And one of the central themes that we seek to convey to real estate consumers across Australia is the importance of building your team before you build your portfolio. We think it's critically important to have a team of qualified professionals around you before embarking on the purchase of a home or an investment property. And the underlying premise of today's discussion is that legal advice at the right time is essential for investors and for home buyers. And at the right time, in simple terms, is early, because the record shows that far too many Australians seek advice after the event, and often it's too late. Within that broad topic, there are lots of different issues, and to help us to unpack all that, our special guest today is Tom Wood of FC Lawyers. Tom, welcome.
Thanks very much, Terry. It's great to be along today. I very much appreciate the chance to have a chat with you.
Yeah, I mean, there are so many issues that fall under that broad headline that I've just introduced. Perhaps we could start with the simple subject, or the not so simple subject of contracts, and the importance of seeking qualified legal advice before signing anything.
Well, I guess it does depend somewhat which state you're in. So I'm in Queensland, and in Queensland, real estate agents still prepare the vast majority of contracts. And so the consumer needs to make that decision to seek legal advice and accounting advice before actually entering into the contract. In New South Wales, solicitors prepare the majority of contracts. So the sellers are well informed before they sign anything, but the buyers also need to get legal advice before they sign anything. So I guess there are many reasons for getting advice before you sign. What I've found is that the reason that people don't get advice before they sign, well, there's a couple really. One is there's time pressure, and I was just saying that before we started the formal broadcast. There can be pressure where you have multiple buyers and a desirable property. But I think that lawyers these days aren't like they used to be. It used to be that a draft contract would sit on a lawyer's desk for a few days, gathering dust, and then eventually the lawyer would get around to it. Nowadays, with technology and consumer demands, quite correctly, lawyers have had to sharpen their act and be geared up to give advice same day, within 24 hours, to satisfy their clients' demand for timely and comprehensive advice. But there's so many reasons to get advice early. And I guess we can start with really tax and accounting advice. And this is an area where lawyers work very closely with accountants. If it's a mum and dad buying their first house, then generally mum and dad, or the husband and wife, will go onto the title and will be the joint owners, but not necessarily. And this is where, especially if a buyer is buying a second or third property, looking at buying commercial real estate, or it's best for them to consider entering into a contract under a trust or a company structure. Sometimes the buyer won't even realise that they need to ask the question, and then they sign a contract and then get a big surprise later when, as an afterthought, they send it to their accountant or forward it to the accountant, and the accountant says, look, you really need to be looking at buying in the name of a company as trustee for a trust. Let's set that up for you to buy the property in. And so then it has to go back to the solicitor for the buyer to negotiate with the seller to make things right. And in Victoria, that's able to be done quite easily, because the law there says that you don't pay double stamp duty if you change the buyer entity midstream between contract and settlement. In Queensland, the alarm bells go off, however, because double transfer or double stamp duty is payable where you change the buyer entity after the contract has been signed. And that's the case unless you go cap in hand to the seller and ask for the seller to agree to the contract being rescinded and replaced with a fresh contract in the name of the new entity. And look, to tell you the truth, most sellers are happy to do that. They've got a buyer, they've got a deal, and they're generally quite cooperative, but they don't have to agree, and that's the key. So if the market's on the charge and prices are on the way up, there might be a backup buyer there, and the seller may not wish to continue with this buyer Therefore, the poor old buyer has to suck it up, and if they want to get the property and buy it in the name of the new entity, they have to pay the double transfer duty. You don't see that too much, but it's a shock and a surprise to the buyer. And really, when you're investing, it should be all about control and understanding what you're getting into.
So we're talking about the importance of getting the buyer entity right. What are the determining factors there? Is it about the tax position? Is it about asset protection, distribution of assets to children? What are the key issues that might determine your decision about the name of the buyer entity?
There's so many. Where you've got an asset protection perspective, you may have a risk person who owns a business. So the classic situation there is that the non-risk spouse, who perhaps isn't the sole director of the family business, will own the freehold property, because generally that means that property is protected from creditors of the business. So if the risk partner goes bankrupt or the business gets into financial difficulty, then the real estate is generally protected if it's in the name of someone who's not at risk under the business. Of course, where you have both spouses signing personal guarantees of business loans, that is somewhat nullified, especially if the bank takes a mortgage over the property owned by the guarantors. But a lot of times that doesn't happen. The banks don't generally go down that further track of taking the mortgage out over the guarantors' properties. But again, this is the kind of thing you need to get advice on, rather than blindly going in and signing a contract in the name of both spouses. So that's asset protection. What else is there? You have a situation where, I've seen one situation where the buyer intended to buy the property 99% in his wife's name and only 1% in his name, because he was the risk party. And so they intended to buy the property as tenants in common. And what that means is that the husband only owns 1% of the property and the wife owns 99%. However, something was lost in translation, and they were actually noted on the title as joint tenants, not tenants in common. So what that means is that legally, it's as if they own half the property each, if you like. It's not quite like that, but ultimately, when the husband went bankrupt, the wife lost the house to creditors, because it was assumed that the wife owned a far more substantial share of the property. The husband owned a far more substantial share of the property than was actually the intention. So that was a boo-boo that cost those people dearly, unfortunately.
So to the ear of the average layperson, joint tenants and tenants in common would appear to be the same thing, but obviously they're not. So what are the important differences there that people need to understand?
Well, just briefly, if you own a property as joint tenants with somebody else, then if you pass away, then the survivor automatically inherits that property without it even needing to be referred to in your will. So jointly owned property is really outside your estate. It's totally separate, because it's as if both people own the whole property. Tenants in common is very different. It's a set share of the property, so 50%, a quarter share, a 1/10 share, or what have you. And so it's something that you can pass in your will as part of your estate. That's the basic difference. So you quite often see where friends or family members who aren't spouses, maybe business associates, are buying property together. They will almost always buy property as tenants in common rather than as joint tenants, because they want to keep they want to be clear, their right in the property is a certain fixed percentage.
Okay.
Just while we're on that, Terry, I've got another example where clients did wish to hold property as tenants in common, but instead they put down joint tenants on the transfer, and that would have been potentially disastrous. But they were able to contact the title office and note that it was an error, and so they fixed things up before it got too bad.
Tom, when we're in past days discussing the various topics we would cover in this webinar, that the term presumption of advancement came up a few times, and that's something I have no understanding of it all, and I imagine the average layperson wouldn't. What does that mean? Why is it important?
Well, it's important, especially these days where people are trying to get into the property market, and often in order to do so, they need to do so as a group or do so with friends and family members. However, it's very important to document the relationship between the parties and to document the share that each person is to hold in the property. And even though it costs you a few dollars in legal fees to get one of these co-ownership deeds prepared, it's money well spent. The deed will not only say that A owns such and such a percentage, B owns such and such a percentage. It'll cover things such as, look, we're all getting into this property as an investment property. We'd like to have to own it for at least 2 years before any of us can get out or sell. That goes in there. What if one of us suffers total and permanent disability? Well, we want to have insurance in place to insure us so that we can pay out the person who suffers total and permanent disability. That goes into the deed of co-ownership. A right of preemption, which is a very basic thing in shareholders agreements and partnership agreements. If a party wants to get out, then the others have first crack at buying that person out. And how is that share to be valued? All these things go into the co-owner's deed. And if you don't do that, well, I'll read a couple of examples that will illustrate what the presumption of advancement is. I saw a situation where a wife who held a joint interest in property with her husband became bankrupt, and there was no issues in relation to family law. The husband and wife were still happily together. The bankrupt wife and her husband each had a half interest in the family home, and the house had significant equity that was very attractive to the trustee in bankruptcy, obviously. The husband said, look, my wife's contributions to the property were actually very limited. I funded the initial purchase of the property, and so the bankrupt wife's interest in the property was really negligible. Unfortunately, they hadn't documented this. So they hadn't documented the fact that the husband had essentially provided all the funds, and so the wife really only held her share of the property as trustee for her husband's benefit. As a result, the husband was required to buy his bankrupt wife's 50% interest in the property from the trustees in bankruptcy. So trustees in bankruptcy were very happy because they had some money in the kick from the husband having to buy out a 50% share. So there's a presumption. I'll run through the second example first of all. This is where there was a relationship between parents and an adult child. The adult child became bankrupt and owned the property. Now, the adult child in this case was the sole owner of the property, and following the bankruptcy, it was seen that there was substantial equity in the property, which would need to be realised for the benefit of the bankrupt estate. So the bankrupt's parents said, look, we funded the deposit that enabled our child to buy the property, and that was actually the case, but there was no formal agreement in relation to the provision of the funds. And so as a result, the presumption of advancement, the presumption that the parent's share was a gift to the son, and therefore the son actually owned it. Because there was no formal agreement that documented that, the presumption of advancement could not be rebutted. And so the bankruptcy trustees were in the position of being able to either require the parents to buy out their son's share or to sell the property and keep the money. So it's presumed to be a gift by the person who is putting in the purchase price or making a contribution, in the absence of a document that says, hey, this is who put in what and this is what happened. So it's very important to document your intentions. And again, there's a time issue, Terry, because people are driving around looking at properties with their mates or with their family members, and they want to get to contract quickly. And it does take a few days to woe back, to seek legal advice and to get a co-owner's deed drafted and signed. And so the buyers are very impatient. They want to get into the market. The agent's breathing down their neck, and so it can be quite a pressurised situation. So that's why it's a good idea to put these things in place well before you even buy a property, and then you can insert property address here, and the document's already done.
Yeah. So it just reinforces the importance of getting legal advice, but getting it early before you're out there actually looking at property when things might start to become urgent. It can be as simple as sitting down with someone like yourself for an hour and sorting through some of these issues, and can prevent a whole welter of problems, very expensive ones potentially later on.
Yeah, and then not just looking at buyer entities, Terry, but you need to just get a review of the contract conditions generally. And this is from both the buyer and seller's point of view. Every deal's different. Lawyers don't want to stand in the way. They want to, the buyer wants to buy and the seller wants to sell. So both seller and buyer are seeking legal advice, but ultimately they want to move the property or buy the property. And so it's just a matter of both parties' interests being protected in a well-drafted contract.
So we're generally talking about contracts and the importance of getting that right and consulting a lawyer early to make sure that the right things are in contracts. Some of the conditions that might be important to people, what are some of those that crop up regularly?
Well, if you're buying a block of land from Stockland or from a reputable developer who the market knows their product, knows their reputation, and knows that they have a good reputation in the industry, it's less important to look at putting things such as a due diligence special condition in there, because there's quite a low chance of the seller doing the wrong thing and selling you a pup. But that's not to say that you shouldn't still consider it. So I guess you need to craft your offer, if you're a buyer, in such a way as to be attractive to the seller, but also protect your interests. And so it can be quite a fine line. You need to look at, if you're buying a house, a building and pest condition. In some states, building and pest reports are provided with the contract to the buyer, so there's less of a need to do that. But in states such as Queensland, where it's very much buyer beware or caveat emptor, the buyer needs to protect themselves by either making their investigations before they sign, if there is pressure there to have an unconditional contract, or putting things in place such that they make a conditional offer, which is conditional on, say, building and pest and maybe due diligence, and then they get cracking once the contract is signed and they do their building inspection, they do their pest inspection, they get their urgent searches out and back within, say, the 14 days or the 21 days. And what I find nowadays is really sellers, quite rightly, don't regard themselves as having a deal until the buyer has gone unconditional on those sorts of conditions. Finance is obviously the big one as well, Terry. There's a big difference between making a cash offer and making a subject to finance offer. But many sellers are realistic, and if there's a 14 or 21 day due diligence condition, then they're perfectly happy for there to also be a 14 or 21 day finance condition. But they don't get too excited until the buyer has gone unconditional on all those things. So it's really a matter for the buyer to determine their risk appetite, how many conditions and what the terms of those conditions are to be, and then to do the deal. And the agent's got an important role in this, in advising the seller, and the buyer and seller's lawyers also have an important role.
The issue of settlement and how important is that?
Well, again, it depends on the property, Terry. So in Queensland, traditionally it's been 14 days finance, 30 days settlement. These days we're seeing more 21 days finance because of the banks taking longer to process applications, 14 or 21 days due dil because searches can take up to 10 working days to come back, and a 35, maybe 45 day settlement is more common. But you still see 30-day contracts, 60-day contracts. Sometimes you have a long settlement. So especially at higher end properties, luxury properties, which are harder to move, and the seller wants to move into a similar property. They want to sell their luxury property and buy another good property. Quite often they want to stay in there for a few months, or the buyer might want to move in for a few months but not be able to settle for a few months. And so that's where you see a 90-day settlement sometimes, 120-day settlement, or sometimes longer. So it really depends on what the seller wants and what the buyer wants. If the buyer comes with a super attractive offer but can't settle for 90 days, then the seller may be willing to take, or not take the risk, but willing to sit and wait that long before they get their money. Whereas if it's a heavily conditional offer, then the seller might be impatient for that buyer to get cracking and go unconditional so they can move on if this one falls over. It really depends. So it's all about crafting an offer for the circumstances. But we generally do advise, unless lawyers don't know the property. The lawyer doesn't drive past the property. I guess we all Google Earth it generally just to get a feel for it. So if I see a contract, I'll normally have a look on Google and check the property out. But the lawyer is not responsible for making sure that there's no defects with the property. The lawyer has to, and the buyer has to get that information from the experts, from the building inspector, from the pest inspector, from the search results from the various government bodies and local councils. But as far as length of settlement goes, what we're finding is commercial property generally has a longer settlement time because the buyer usually wants to review the lease and make sure the lease is acceptable. So under the standard REIQ contract in Queensland, they've got a couple of weeks to do that unless those conditions are changed. And again, this varies between the states depending on the terms of the standard contracts that are used. But in commercial property purchases, they are almost always subject to a due diligence. So the buyer can suss out the lease and also do searches of things such as the permitted use of the property, just to make sure that it's allowed to be used for what it's being used for. The tenant business is crucial to the landlord because the success of the tenant business enables the tenant to pay the landlord rent. And most landlords want to have a set and forget investment where they have the income coming in and they don't need to worry about it. So for those reasons, a buyer of commercial property will want to have a close look at the leases and suss things out. Another important thing to look at is the body corporate setup. So where you're buying a unit, and this is fairly bread and butter for property lawyers, you get a body corporate inspection done and you check out the state of the body corporate. And generally speaking, they're fine. But very occasionally you'll find a major issue with the body corporate that will cause you to bring something to your client's attention. If there's a huge defect in the waterproof membrane, for example, and there's concrete cancer through the building and the body corporate has been getting quotes for many thousands of dollars to fix the structural problem, then a buyer might be a bit less keen to buy into that body corporate because obviously the owners have to fund that sort of work through a special levy if it's not already accounted for and there's not enough money in the sinking fund. So you check out recent AGM minutes, you check out some recent correspondence as part of your body corporate search. What we find is with duplexes especially, that many of them have been built by the previous owner and they've got council approval to build them and they don't actually go the next step. They register the plan to create the body corporate, to create the lots, lot 1 and lot 2, say, for a duplex, but they don't actually hold any meetings or administer the body corporate. And then 10 years later, they want to sell one of them and then the buyer says, well, where's the body corporate records? And of course there aren't any. And so then the buyer needs to make a decision about whether to insist on the seller setting things up properly, or if the buyer thinks they're getting a bargain and they've met the neighbour and they seem like nice people, we can do a deal to sort things out later, they might plunge on anyway and go ahead and settle rather than rocking the boat if they're getting an absolute steal. So it's all about making informed decisions and a decision to proceed with a property that you know has some kind of problem or defect is still a valid investment decision because you're making it on an informed basis.
Just a reminder to everyone who's tuned in today that if you've got any questions for Tom Wood of FC Lawyers, type them into the chat box or the Q&A panel and we'll do our best to address the questions as they come through. We're talking about due diligence matters, Tom, and I think a lot of people are signing a contract think that an easy out, if they want one, is the building and pest inspection, them being happy with that. What's the reality around the building and pest inspection clause and how should that be handled?
Well, with building and pest, if there's a nail sticking out of the veranda you can't use that as the basis for termination. So the standard contracts in Queensland, and I'm sure in the other states, say that the buyer must act reasonably. And so the usual way that it goes is that the buyer will say, well, here's my building inspection and these are the problems. And then they talk turkey about whether the seller is to pay for repairs. And then the contract stays conditional on building and pest until those repairs are done to the buyer's satisfaction. Or more often you see a price reduction. They'll knock 5 or 10 grand off just to, the buyer will get a quote saying this is what it's going to cost to fix the problem, and they'll bargain a price reduction. That's the most common way that we see building and pest matters resolved. But one thing we see a lot of is where there's not a final approval of the house. And there are many, many thousands of properties across Australia where a building approval was obtained. The building was built, the house was built, say, but for whatever reason, everyone got excited and forgot to do it or didn't get a final certification done. There's no final approval. And so then we'll have the client coming to us, especially where they haven't got legal advice before they sign the contract, and say, look, the search shows that there's no final. Can I get out of the contract based on the building and pest inspection? And unfortunately, the answer to that is generally no, because the building and pest inspection condition is very specific and it relates to defects in the building itself. So in the structure. So if it's full of termites, if it's got a wall that's structurally defective, it doesn't relate to the paperwork. So if you have a house that's not got council final approval, that's a regulatory and compliance issue. And in the absence of a broad due diligence condition, the buyer can't use the building and pest condition to walk away from a contract where there's no final council approval. This is just speaking in general terms, and it may vary from state to state.
And when you're doing your due diligence and discover there's no final council approval for an important structure, that in itself is not a valid reason to get out of a contract?
If you have a due diligence condition, then you can tell the seller, look, we're reasonably not satisfied with our inquiries because it shows that the house hasn't got a final. And so then negotiations will ensue, whether it be for the seller to quickly get a certifier out and get things ticked off. And we do see that a fair bit. So you might find that settlement gets extended for a couple of weeks or for a month, and the seller then races off and makes things right. They pay any outstanding fees to the council, and a certifier or council inspector comes out and ticks things off. So the seller has to spend some money, and it may delay things by agreement. And then the buyer has that final in their hot little hand, and they're happy that they're buying a house or a property that has a final approval. Because it does come down to the price they're paying as well. If the buyer can fairly say, look, I'm paying X dollars for this property, and it's on the assumption that it's according to code, then it's hard for the seller to say, look, bad luck, we don't accept that, especially where the seller had knowledge of it not having had a final. Sometimes it's a surprise to the seller if they didn't do that search themselves when they bought the property. So that's an issue that you do see sometimes, but with civil and commercial bargain, you can solve these problems. It might be a price reduction. The buyer might say, okay, I'll still take it off your hands. They'll go away and do their homework behind the scenes, and they'll find out that it's likely that it's a fairly easy fix. And so they'll proceed anyway, or maybe ask for a bit of a reduction in the price. So it's all about informed negotiations, I suppose. But you do get things with due diligence, Terry, such as encroachments. You need to make sure that look at whether to do a survey of the property. That's another thing that we see pretty frequently.
Yes, there's a case study that you mentioned, somebody buying a business and the associated freehold and didn't do the required due diligence and found out too late that there was a problem.
Yeah, that's where you have maybe a pool that's overhanging the neighbour's boundary, or a veranda, or sometimes a wall. And so it's always recommended that a survey be done, but a survey can cost $1,500. So if it's pretty clear that the house is in the middle of the block and there's not anything encroaching on the neighbour's property, then I guess the only risk is that the fence doesn't run exactly along the boundary. And you do sometimes see fence lines that aren't quite in accordance with the boundary. But again, it's a commercial decision for the buyer to make. and the buyer can look at the plan, and they can look at the fence line, and they can judge for themselves whether it's close enough. If it's 200 mil out, then it's out, I suppose. And so technically they could say, well, we want the seller to move the fence so that it's on the boundary, so that we're not missing out on our little sliver of property.
Yeah.
So,
and the case study you mentioned, the business actually encroached substantially on a neighbouring property, and that had to be negotiated, and it was probably an expensive outcome for the buyer.
That's right. It needed, for that particular one, it needed a reconfiguration of land, so that the seller had to actually buy the neighbours the sliver, which involves a resurvey of both properties and the issue of fresh titles for both properties. And only then was the property that was being sold correctly and fully described in the contract, and the buyer was then happy to go ahead. So it was quite an expensive exercise. Or the buyer might decide to take on that risk and buy the property with that problem and back themselves to negotiate with the neighbour themselves. They would almost certainly ask for a price reduction, though, that would at least be equal to what the value of the sliver of land is that they've got to buy from the neighbour.
Just another example of how trying to save a little bit of money by not having a survey, for example, as part of your due diligence, can end up being a classic case of false economy.
Very much so, and it's tough. People are paying very high stamp duty on purchases across the nation. It's a major revenue source for state governments. They're paying establishment fees and bank fees to get their loan. They're paying legals. They're paying search expenses. And to add another expense, such as a survey, can seem like a lot of money, but and also can they might think they're saving a few bucks, but it is a case of false economy. That said, I must say that most buyers don't go ahead and get a survey done, but they're making an informed decision not to do so.
Yeah. Okay. There was another case study you mentioned that was to do with a vacant land purchase and the soil test not being done.
Yeah, now soil is always a bit of a tricky one, because most well-established houses and units, if they've been there for a very long time, you can normally assume that the soil is not going to cause the foundations to crack and the building to fall down. Soil tests are more where you're buying a vacant block of land in an estate, and that's where, if soil is poor quality, it can add a lot of money to your building costs, because you need to spend a lot more money on piering and foundations that you may not have budgeted for. So that's where the soil test can determine that there is a problem here and that it's going to cost you X dollars more than you expected to build your house. And if the contract is subject to specifically a soil test being satisfactory, or even more generally a due diligence investigation being satisfactory, that would cover soil as well, a general due diligence condition if it's well drafted. That then enables the buyer to go to the seller and say, look, here's this problem, let's work it through, and again, it might be a price reduction of the value of the piering. It might be the seller has to somehow bolster the property to make it, or fix the soil problem somehow. It's a fairly rare problem, because most developers, they will have done their own soil inspections in getting council approval and in marketing and developing the estate. So it's just something you don't see very often, but something that you need to be aware of with vacant land, really, and especially in new estates.
Speaking of vacant land and building a house, we read often in mainstream media about builders going broke, leaving the buyer, the people ultimately are building the home in the lurch. What can people do in those circumstances, or how can they protect themselves in the event of that happening?
Well, you need to do your homework on the builder and choose a reputable one, essentially. Building contracts are fairly standard in form, and they can be tweaked a little bit, I guess. You need to make sure when you're entering into a building contract that you're 100% certain on all the money clauses, what things are going to cost you, or what it's going to cost you to build the property, what happens where there's a variation, what happens where there's an unexpected problem. Those things should be very clear in the buyer's mind, so they know what they're getting themselves into and what things may cost if things go wrong, the worst case scenario. But first and foremost, really, the building contract it's an important piece of paper, but it's a piece of paper. So it's more important really to be confident in the reputation of the builder you're dealing with. So it could be as easy as asking them to give you a reference or a couple of references from satisfied customers, or even better, find a friend or someone you know who's used that builder and ask them about their experience rather than getting the builder's own recommendations. That'll be a source of great confidence if you get a personal recommendation from someone who's used the builder. You do a quick search of their license, and it's quite easy to do in Queensland, a QBCC search, just to make sure that they're registered, for example. You can do a company search of the building company and just make sure that it's not in administration or liquidation or something like that. But it's really just being a bit savvy and doing your homework on the builder.
Okay. The whole area of finance, I know we've touched on finance approval, but there's the issue of just the wording. Sufficient to settle was a set of words you thought was important.
Well, yeah, in Queensland, the finance clause says the amount of finance that you obtain, the date by which you have to obtain it, and who the financier is to be. And from the point of view of the buyer, it's always best that it be as broad as possible. So that's why you'd always say, rather than if you're buying a property for 400 grand, say, and you only need finance for 200, then it's more difficult for you to say, well, we didn't get finance approval, because if you're applying for finance for 200 on a property that's worth 400, then it's, as long as you've got a job, it's pretty likely that you're going to get it. And you have to act reasonably in deciding to terminate a contract under finance. So it's far better for a buyer to put in there sufficient to settle, quote unquote, which means that they have to be able to borrow enough to settle the property. And if they can't, they can walk away from the contract and get their deposit back.
Okay, so perhaps we can move on to the old thorny issue of buying something off the plan and what that introduces to the equation from a legal standpoint.
Oh, beg your pardon, Terry, that last bit?
The whole issue of buying off the plan and the various legal issues that entails, as opposed to buying something as that is already established.
Sure, yeah. Similar to a building contract, do your homework on the developer, speak to happy customers, look at the developer's history, and basically it's much easier where you're dealing with an established builder rather than someone who's doing it for the first time. Not to say that a first-time developer or a first-time or an inexperienced developer isn't going to do a great job and deliver, but you just need to look closely at the contract and make sure that it fits the bill. If you've had an important representation made to you by the agent, and that representation is crucial to your decision to purchase, then you need to get that put into the contract and document it, so that if the end result isn't what you expected and what you were promised, you can walk away from the contract. And if at the contract negotiation stage, the developer refuses to put in your requested condition, then you can ask why. You can decide for yourself whether to sign the contract at all, or whether to take the risk of the developer not doing what they said they're going to do. I guess it's difficult though, also because the developer has to have a certain number of unconditional contracts before they can get the development out of the ground, whether they're developing land or a block of units. They need to have commitments, unconditional commitments, that a bank is satisfied are rock solid contracts, meaning that the bank will get paid back once settlements happen. And if you put in conditions that allow a buyer to walk away too easily, or sometimes that allow a buyer to walk away at all, the bank won't include that particular contract as a qualifying contract for the purpose of it giving finance to the developer to get the development started. So we talk about putting things in contracts. You can put in that the agent has, or the seller promises that there will be a view of the lake, and that the gazebo that is next to the pool out the front of the property will be certain dimensions, rather than unexpectedly being too large and blocking a view. And those are very specific conditions. And if the developer is confident they can deliver in accordance with their plans and designs, then you'd think they should be happy to put that in there. But at least you're having the conversation. So views are a classic, where the property is built and there's some view obstruction, and the buyer, unfortunately, usually can't walk away in the absence of a specific condition. because off the plan contracts are generally quite seller friendly, quite developer friendly, because as I said before, the developer wants to have solid contracts. So there are not many outs for buyers generally. Buyers can certainly have a due diligence condition in there and a finance condition. As is usually the case with off the plan, finance approval is only ever indicative though. So where a unit block is being built and a buyer gets financed within 14 days or 21 days, then the building gets built. And if the market has gone south in the meantime, then it's not unheard of for the bank to refuse final finance to the buyer. And of course, it's too late for the buyer to walk away because the contract is no longer conditional on finance approval. In practice, the buyer will usually race around and try and source alternative finance at fairly short notice, but it's quite a stressful experience. So again, it comes back to the buyer being confident that the developer will deliver on what it says it's going to deliver on. Although no one can predict the market. Where the market tightens up or goes south, banks' valuers are more cautious and conservative in their approach, and the bank may only value the property at X dollars, whereas previously they were prepared to fund it for Y dollars, and so the buyer has to make up the shortfall. Finance might not be rejected altogether; it might just be reduced, and so the buyer has to find the extra money. So it's an inexact science, I suppose, buying off the plan. But the idea is that you're getting in ahead of the market for a reasonable price because you're helping the developer to get their development out of the ground and done. So if you're a solid buyer, then you'd think that you're in more of a position to be able to negotiate a good price if you're buying off the plan.
And speaking of off the plan contracts generally being very developer friendly, the whole issue of sunset clauses and how they are used and misused is something for people to be aware of and beware of.
Very much so, Terry. Now, it's one of the most important things with off-the-plan contracts. So in Queensland, the maximum, it's not so much an issue for land contracts where you're buying land off the plan, because at least in Queensland, the developer has to deliver a title within 18 months, or else the buyer can walk away and get the deposit back, and that's in legislation. It may differ between the states, but generally land buyers are quite well protected. That doesn't mean that you can't separately negotiate a shorter sunset date. And a sunset date is basically a date by which the seller promises to settle, to have the land development completed, separate titles issued from the big block of land, and then the buyer is buying one of those separate titles. But if a buyer is very, very keen to settle within 6 months or within 8 months or within 9 months, then there's nothing to stop the buyer from introducing that into the conversation with the seller and saying, look, we need the sunset date to be brought back. We don't want to wait up to 18 months. And where you've got the seller who is a fair way down the track of finishing the development, for example, then the seller might be fully confident that they can have titles issued within 3 months rather than needing up to 18 months. And so they may agree to a shorter sunset date. Or their bank, the developer's bank, might not agree to any shorter sunset date in a contract if that contract is to be a qualifying contract to enable the bank to fund the seller. If the seller or the developer hasn't got an approval at the point of sale, then they normally will need they'll need at least a few months to get their council approval, and then maybe a few more months to get the earthworks and the development done. And if it rains, if there's a shortage of supply, if their builder or their contractors go broke, then it might take them a year, whereas they thought it was going to take 5 months. So this is where you have variables, and this is why off-the-plan contracts generally have a fairly generous sunset date. And so it's up to the buyer to make the decision as to whether they're prepared to cop that or not. And it goes with the territory of off-the-plan. And that's the easy one. So land is the easier of the two kinds of off-the-plan purchases. The other one is units. And in Queensland, you're able to have a sunset date of up to 5.5 years, which is a very long time for a buyer to be committed to buy a property down the track. And where it gets to 4 or 5 years after you've signed a contract, there are so many things that could have happened in that time. The buyer's financial situation may be different. The buyer might just be sick of it and want to buy something to get investing and to start getting a return, but they're stuck with a contract that goes for up to 5.5 years. It is incumbent on the seller to only extend or only take a long time, I suppose, if it's genuinely the case that the development's taken them a long time. You do sometimes see a shorter sunset date in off-the-plan unit contracts, such as 2 or 3 years, but often there's a clause that enables the seller to easily extend that if there's unexpected delays due to something outside the seller's control. And those reasons are very broad generally. So it's quite easy for a seller to extend it out to the full up to 5.5 years, say in Queensland. This is where a buyer needs to carefully calibrate their offer. And if the buyer is just not prepared to wait longer than 2, 3, 4 years, then put it in the contract. And if the seller or developer won't agree to that, don't buy the property. So you can take out that unilateral extension condition that allows a developer to extend. On the other hand, the buyer might be very relaxed about waiting for a very long time. They might see the building under construction. If the building is 8 stories up out of a 10-story building and the contract is still a 5.5-year sunset clause, then the buyer might decide, look, we're on a pretty good thing here. It's pretty unlikely that there's going to be a problem, and we'll go ahead and sign the standard contract. And demand comes into it too. If you've got a lot of buyers competing for the same off-the-plan unit, then there's less pressure on the seller to agree to any variations of the contract.
Okay, we've been going 50 minutes. We generally try to wrap these things up roughly within the hour. A few other issues we could touch on, Tom. There's some of the taxation issues, GST, capital gains tax, which do you think is most important for us to cover in the time we have?
Look, I will just whiz through those briefly. Especially if you're selling, it's crucial whether you're selling a house, a block of land, a unit, or a commercial property, to get that accounting advice first. A major question is whether a sale is a taxable supply for GST purposes. So you might think that you've bought a property and you might have then subdivided it into 2 lots and you're selling it. Well, if that's regarded as being an enterprise for GST purposes, then you may be required to register for GST and charge your buyers GST on top of the purchase price. Or is it just the realisation of a capital asset? And in that situation, often there are no GST implications. So you don't want to be stuck, if you're a seller, having to pay 1/11 of your sale price to the taxman unexpectedly because you didn't get your ducks in a row before you signed up. From a buyer's point of view, it's a bit easier because the buyer will know, based on what the contract says, whether they've got to pay GST on top of the price or not. A commercial property usually doesn't have GST at all if there's a lease in place because it's regarded as a going concern. So the going concern exemption will apply and there'll be no GST consequences. Sometimes it's price plus GST and the buyer is fine with that because they might have the cash flow, they've got the money to pay the GST, and then they claim the input tax credit back next time they do a BAS. So often that's not even a problem. It's only a problem where a party is unexpectedly having to pay GST on top of the price if you're a buyer without knowing that was the case, or if you're a seller, you're stuck with a taxable supply without having realised it.
Sounds like an ugly situation. You refer in our previous discussions to margin scheme as an issue to be aware of. What does that mean?
Well, the margin essentially reduces the GST for a seller because it means that GST is payable only on the margin between what the owner bought the property for and what they sold it for. It's only available in certain situations though, and the margin scheme is not available to a seller where the seller paid GST on the property when they bought it. So it's obviously when you're deciding on your price point to sell to your buyers, if you're only having to pay GST yourself on 1/11 of the margin, then the price is going to be less of a cash flow issue for buyers compared to price plus GST. But if you sign a contract up that doesn't allow you to claim the margin scheme, then it's too late for you to later on say, oh, gee, I have to change the contract to allow the margin scheme to apply. That can only happen if you go cap in hand to the buyer and ask the buyer to agree that the margin scheme can apply to it. But you need to actually replace the contract in that case. So it gets super messy. So it's just not something that you want to have to do.
For people engaging in a normal transaction, the sale of a residential property, a house, a home, is GST ever an issue? Is it just something that just doesn't come into play for most people in most transactions?
Mostly for house and land, it doesn't come into play. But you need to seek legal advice on the individual property and the individual contract.
So capital gains tax issues, again, when we're talking about the principal place of residence, it shouldn't be a problem for people, but there are circumstances that people may unwittingly create for themselves.
Yeah, well, with capital gains tax, you need to, again, just if you're buying a commercial property or property as an investment, then obviously you'll generally pay capital gains tax when you sell, and you get the 50% discount if you own the property for more than 12 months. But it's something that not everyone realises, but people know obviously that there is an exemption from capital gains for your principal place of residence. And so if you sell your house, then generally you don't pay any CGT. But it's also possible to buy a property as an investment, and as long as you don't rent it out for a reasonable period, you can retain that principal place of residence status for that particular property, even if you don't actually live there. But if you just put a tenant in on the settlement day, then that's not available to you. So you need to speak to your accountant about whether you should be doing that. There is a bit of a hit to your income for that reasonable period, whether it be 2 or 3 months where you're not receiving rent, when you're desperate to receive income to start paying the loan off. But then if you sell down the track, then you're paying capital gains tax on the sale of the property. Whereas if you hold off for a little while before you lease it out, then you can possibly claim that as your principal place of residence when you sell it. So that's just a little thing you need to keep in mind.
Okay, let's turn to a couple of questions that people have sent through, and urge people the time available. If you've got any questions that you'd like answered today, please bang them into the chat box or the Q&A panel. Colin is referring to a situation where a client had a building inspection, the new house, less than 2 weeks after they moved in, the downstairs laundry ceiling collapsed. The building inspector claimed their disclaimer exempted them from having to pay out. If they'd seen a lawyer, would have there been legal grounds for a claim in a case like this?
Yeah, well, in that case, you're looking at making a claim against the building inspector, not so much the seller, because once you've settled and once you've gone unconditional, it's too late to do anything in relation to the property as far as the seller goes, unless the seller has made some sort of promise to you that the laundry is 100% in good nick, and that condition survives the settlement, so that we still agree to indemnify the buyer if the laundry is not in good nick, which won't be in the contract. So essentially, you need to look at a claim against the building inspector. But as you say, they're quite broadly worded, the contracts, and if the inspector can't get access to a certain part of the property because there's furniture in the way, or because it wasn't safe to do so at the time, if there was a barking dog or it was wet or something like that, then they can simply say we couldn't inspect that properly. And you'll read through in the fine print of the building inspections, often they do say we're not experts in water penetration into properties, or there'll be a very long list of disclaimers. This is where, again, you need to be happy that you're dealing with an experienced building inspector who can spot that kind of thing rather than an incompetent one.
Yeah, I've had plenty of experience myself with building and pest inspections, and there seems to be, for want of a better term, a lot of arse covering in the report by the writer of the report, and you sometimes wonder about the value of the report that you're getting. Not sure there's a lot that people can do other than make sure you're getting somebody reputable. Totally,
100%. Word of mouth is the best way to get a good building inspector and pest inspector.
Colin is asking the agreement between different related clients buying an investment property. We're just wondering about the costs. So I guess cost is probably the thing that stops people the most, engaging the legal advice that they should do, when they should get it. Is that your experience? And the question here is roughly the cost. Is it hundreds of dollars, thousands of dollars to get an agreement between related clients buying an investment property together?
Generally, you'll pay between $1,500 and $2,500 maybe plus GST. Generally, the floor would be that $1,650 including GST, because you need to get the instructions, advise the client on what the agreement means, draft the agreement, and then get it signed up. And it's a piece of paper, and 9 times out of 10 it goes in the bottom drawer, and everyone lives happily ever after. Everyone's shaking hands and on the deal, and everyone knows what's to happen. And so you don't even need it. It only ever needs to be brought out where there's a dispute or a problem, or maybe where you can't remember what you agreed. And where that happens, it suddenly becomes the most valuable document ever, and every word is important. And not just because most people will then say, okay, I remember, okay, fair enough, that's my signature. I will honour what I promised to do. But also importantly, a judge looking at it, if there's a dispute, will say, well, look, you intended this to be the agreement. Why should I vary that? So it is very much false economy to not get one of these co-owners deeds done, where you've got friends or even family members signing up. And it's not that you don't trust them, but it's just human nature being what it is. Things can change, and no one can know what will change in a relationship dynamic between people. And so it's money well spent. Okay.
And just to finish off, Kevin was just asking the simple question. We're both sitting in Queensland. We've talked about a number of Queensland situations and asking whether FC Lawyers operates in other states. I think you may be very close to having an office in Sydney, Tom.
We do. We have a Sydney office, so we can certainly look after New South Wales clients. Also, we have a network of firms to which we refer in other states, so we can certainly help clients or inquirers who have legal needs in any state. Queensland is where our 2 main offices are, on the Sunshine Coast and Brisbane, but we handle legal matters that are all over Queensland. It doesn't matter where in Queensland you are. But yeah, we are establishing our presence in Sydney. Watch this space, and we have good networks nationwide.
Okay, so people like Kim who would like to perhaps get in touch and follow up and seek some advice on property-related issues, how do they get in touch, Tom?
Just simply email me, tom@fclawyers.com.au, or give me a call.
Just to let everybody know who is watching and listening today, and others who have registered for the event but couldn't make it today, we will be sending out a recording of the webinar, and that will have information received. With that, we'll have contact details for anyone who wants to follow up and talk to Tom, one of his colleagues at FC Lawyers. So thanks, Tom, for we've just clicked over the hour, so it's a good time to wrap it up. Many thanks for an interesting and informative presentation on some of the issues that people need to be aware of, and the importance in particular of seeking legal advice, and particularly early before getting involved in real estate transactions and signing contracts. What's your parting word for people out there as thinking of becoming real estate consumers?
Well, I think be informed. Be informed. Concepts that may seem complex can usually be put into simple language. You make an informed decision, and you're more in control of your destiny, and you're less likely to be surprised by things. You don't want to be surprised. You want to be confident in your investing and in your strategies. And so, to that mind, or to that end, seek advice and take advice and make your own decisions. But no, thanks very much for that, Terry. It's been an absolute pleasure to be here today.
Yeah, I've very much enjoyed the discussion. I've learned a lot, and hopefully people out there watching and listening have done so also. Thanks, Tom. Let's do it again soon.
Will do. Thanks very much.
This is Terry Ryder and of Hotspotting, and Tom Wood of FC Lawyers signing off. Thank you very much for your participation today. Bye for now.
Thank you. Bye-bye.